So hi, everyone.
Sure.
Today we have a great guest today, Nancy Morawetz. She's a clinical professor of law at New York, NYU, at New York University School of Law. And I read an article that she wrote, an op-ed, I think it was, on Law 360 about Barton v. Barr, which is a Supreme Court case which goes about cancellation and removal and all this stuff that, as regular listeners know, I don't do. So I thought I'd go to an expert, someone has an opinion on this and knows the facts better than I do, to discuss it. Thank you so much for coming on.
My pleasure. Thank you for inviting me. I think Barton is incredibly important for all of your listeners because although you might think that this is a technical issue in removal defense and the only people who need to understand this case are people who do removal defense, it's in fact extremely important for anybody who's filing any application with USCIS, including an application to change your status, adjust your status, or seek naturalization, because any contact with USCIS has the potential to put somebody in removal proceedings because the grounds of potential removability are vast.
Yeah.
And they're in a sense designed to be vast. And the safety valve for being subject to removal has always been that you can seek cancellation of removal, or I should say it's always been since 1996. Before 1996, there was a form of relief called 212C relief for permanent residents and a more generous form of suspension of deportation for people who were not permanent residents. So Barton is huge in terms of closing off access to relief in a removal hearing if a client happens to wind up in removal, which could happen for anybody. Anybody could wind up in removal. And what Barton says is that the requirements for cancellation of removal, which, so for permanent residents, those requirements are permanent residency for 5 years, continuous legal presence for 7 years, and no aggravated felony conviction. So in those requirements are, what the Barton case does is it takes the part of that, which is continuous legal residence of 7 years, and creates a new bar by the way it interprets conditions that can stop continuous residence. So this sounds super, super technical, but the reason it matters is a lot of people begin their legal residency in the United States when they're, 12, 13 years old, 14 years old, whatever, and incur some relatively minor criminal problem when they're 18 or 19 or whatever. It could be violating a marijuana law. It could be, a petty theft. It could be a turnstile jump. It could be all kinds of things. And what this decision says is that those things that happen in the first 7 years have huge importance down the line. It doesn't matter if the person's put in removal proceedings 4 decades after coming here. Mm-hmm. The clock for cancellation of removal can stop in those first 7 years for reasons that would not have even made the person deportable. And that's what the decision does. It is enormous. Mm-hmm. And probably the best example of how enormous it is drug offenses, because drug offenses for inadmissibility, anybody who practices immigration law knows that for inadmissibility, it's any violation of a regulation or statute here or abroad, which is either an admission, which is a technical term. There are certain things that are required for somebody to admit to a crime, or a conviction is a bar to admissibility. Whereas is a ground of inadmissibility, I should say. And you might seek a waiver or whatever, but it's a ground of inadmissibility. Whereas for deportability, Congress very intentionally in the 80s put in exceptions. And one of the exceptions is that if you have a first offense, meaning conviction, of possession of marijuana of less than 30 grams, that's not a ground of deportability. And generally, deportability requires a conviction. It doesn't just require conduct and an admission. So what Barton does is it allows the inadmissibility grounds, which are really broad and could be lots of people who've gone on to have exemplary lives. It allows those things that happened in the early years to cut off access to a relief hearing. So it's a horrible, horrible decision. And just in terms of the result and what it means for immigration practice and what the threat is to the millions of people in the United States who are permanent residents. It's also a threat to people who are not permanent residents, who might be seeking non-LPR cancellation. So it's a threat to all of those people, but it is most shocking in its effect on permanent residents because of the long history of immigration law, which has been, has not been easy on permanent residents, but has made sure through decades and decades of history that there is an available method of relief before an immigration court.
The protections that immigrants get is just getting attacked. I mean, the administration itself is attacking daily, but seeing this from the courts, it takes the next level, and there's not much recourse at this point when it's such a major decision to deal with it. And you can't even be comfortable with being a naturalized citizen with the denaturalization task force, and they sell it as if they're going to go after some sort of murder or something like that. But they're going to pick on small-time people who can't defend themselves. That's how it usually happens. So there's massive insecurity in being an immigrant in the United States, which makes it really hard until Congress really steps in and does something, which is always silent on these matters. And I think we're going to have to wait a couple more years or a decade until Congress actually does something helpful immigration. And to my view, helpful is for the whole society, just kind of let people live their lives when it's minor things.
Mm-hmm. Well, this stop time rule is a good example of the kind of fix that requires legislation. I think it requires legislation at this time, and it's required legislation ever since the law was enacted in '96. There have been issues with the stop time rule. And when people understand the rule, there has been broad bipartisan agreement that this stop time rule should be fixed. Mm-hmm. And so, of course, things happening in Congress depends on a big bill and having the momentum to have a law changed, which I think could happen. I think it could happen for a variety of reasons. And this particular issue, it's interesting because the provision at issue in Barton, this very technical issue that stops the clock in the first 7 years, even if you live here with nothing sort of moment for many, many years afterwards. That is something that wasn't in the House bill and it wasn't in the Senate bill in 1996. So as bad as the 1996 law was, these were not part of the 1996 law. And so they came into the law in the conference committee. Now, if you sort of have studied high school civics, you think a conference committee is the members of the House and the members of the Senate. They come together, they sit down, they talk through their differences, and they develop something. Well, that's not how it actually works a lot of the time. Often what happens in conference is done by staff. In this particular conference, the Republicans that controlled the conference did not even allow the Democrats to participate. And at the end of the conference, only Senator Feinstein signed the conference report. So this provision was added in the conference report. It didn't go through the House or the Senate. It was and in the conference report, when they described the provision, they described it as something that made the person deportable, which is now what the Supreme Court has said is not necessary. It then went in front of the two houses, and this was when Clinton was president, and there had been a shutdown of the government the year before,
Hmm.
and it was part of this omnibus budget deal which got enacted. So the origins of this are that nobody thought about this except whoever wrote it in the conference report, and it just became the law. And when people started looking at it afterwards, there was a bipartisan effort to fix a number of the 1996 laws. And on this particular provision that was at issue in Barton, they would have just eliminated it. I mean, leading Republican congressional figures like Henry Hyde and James Sensenbrenner would have just eliminated it. So it's a very strange thing that this provision that nobody intended in the first place, that nobody defended a few years later, has now been read by the Supreme Court in the most extremely harsh way imaginable, in an opinion that I think is not supportable.
The Supreme Court is making some wild decisions. I won't go into this, but the recent one where they said the Ninth Circuit, they undid the Ninth Circuit decision about the free speech and be able to talk about immigration and options that they have. And one justice's idea that the overbreadth doctrine for First Amendment maybe should be done away with. It's kind of shocking seeing that this kind of stuff coming. It's kind of law school con law kind of stuff coming back, but I was really surprised to hear this kind of stuff. But it's very disappointing. We'll see what happens. You know, sometimes in the darkest night, that's when the sun comes out.
Well, I think that when the courts become very bad, that's when the need for Congress to act is greater. It's when the need for people to mobilize politically around the issues becomes more important. You know, so there is some balance there. But in the meantime, there are going to be a lot of very tragic stories coming out as a result of this decision. But just picking up on that case you were referring to, United States versus Sinning Smith, the Supreme Court, you know, was outraged that the Ninth Circuit had reached out and decided an issue that was not in front of it, and it said, well, that was a terrible thing to do. And what was odd in that opinion is that nobody had argued that in front of the Supreme Court, so they just reached out themselves to do what they did. But if you look at the Barton case, the entire logic of the Barton case is built around a concept that wasn't in the legislative history, it wasn't in the briefs, it wasn't in the oral arguments.
Yeah.
And so they created a justification. They interpreted the law in a very, very harsh way that I think was a disingenuous reading of the statute, and then justified it with a policy idea that was not anywhere in the legislative history. It was just the policy of the Supreme Court, which is exactly what the conservative wing of the court is supposed to be opposed to.
Exactly. It really delegitimizes the court by this kind of hypocrisy, and it just, I mean, their whole history is them of just picking up arguments that weren't in the original briefs. You see this all the time. So just when I woke up in the morning and I got a bulletin that this case was decided negatively, I'm like, oh, this is an easy case. Of course they're going to approve the Ninth Circuit. Then I saw the reasoning. I'm just like, just baffled. Like, this doesn't make sense anymore. It's kind of up is down, down is up. So it's that kind of stuff is just really frustrating as an attorney and really as an American. But let's talk a little about your background. How did you get involved in the immigration space originally?
So I started my career doing government benefits law, Social Security, Medicaid, disability, different things like that, and then moved from practice into being a clinical professor, in which I was doing a variety of civil work. And in 1996, my husband, who's an immigration attorney, came home and started telling me stories about his clients who were affected by the 1996 law. And the immediate issues in 1996 had to do with retroactivity, whether the law passed in 1996 applied to people who had pled guilty to convictions years earlier. And I became very interested in that issue. And so I helped in the litigation around that question, which went on from 96 through 2001. So I was involved in lots and lots of litigation. really as a pro bono thing. It wasn't part of my clinical teaching. I also became interested in the issue in a scholarly way. I wrote an article about retroactive deportation laws. And as I became more interested in the subject, I came to really want to do this as my clinical work, so that instead of having a general civil legal services clinic, a colleague and I began the Immigrant Rights Clinic at NYU. And I've been doing that work now for, let me see, 21, 22 years, something like that. Yeah.
That's wonderful. Yeah, clinics are so wonderful, and they're spreading. So many law schools are starting these clinics, and I mean, just I guess thousands of people are getting help that they couldn't get anywhere else. So it's a wonderful experience, and the students get to really get hands-on on experience. They graduate knowing what to do, which is really important for lawyers in this economy, particularly. Nancy, thank you so much for coming on the show. If someone wants to contact you, is there a best way to do that?
My email address is nancy.morawetz@nyu.edu.
Wonderful. Thank you so much, Nancy. Hope to have you on the show again. You're a great resource.
Okay, thank you very much.
You're welcome. Have a
Bye-bye.
great one. Bye-bye.